Uh, another important topic that we are going to take today is NCRB report on prison inmates. National Crime Records Bureau. It is under the Ministry of Home Affairs. ठीक है? तो NCRB has presented a report on prison inmates. The very important point to note here is, whenever such a current affair you are studying, what you need to look for is, if you are talking about prison, if you are talking about education, for example, so which list it falls in, state list, concurrent list, or union list. It of course falls in concurrent list, right? If you are talking about Forest Act, the forest governance falls in which list, state list, union list, or concurrent list. This is what you have to look for at the first instance. Okay, now prison management prison management falls under the what, state list. Okay, the management of prisons is vested with the states. Now let's see what the report says. Why news? Because 76% prisoners are under trials. It has been highlighted time and again that India is having a disproportionately high number of under trials. Now what are under trials and what are convicts? Okay, so we need to understand the basic difference. So under trial is someone who has not been convicted yet. Who has not been convicted yet. Conviction means that your guilt has been proved. For example, if someone is charged with some offense and that guilt his guilt is proved in the court of law, that is called conviction. Okay? And then he becomes a convicted prisoner and not a under trial. So under trials are those persons for whom the conviction has not happened yet. But if the conviction is not happened yet, the problem arises because if you are not proven guilty, so you are innocent. If you are not innocent, okay, innocent until proven guilty. Okay, innocent until proven guilty is the foundation of criminal law or basically civil laws. So a person is innocent unless and until a court of law convicts him. So if a person is innocent, why is he put in jail? Okay, that is the first question that arises into our minds. So basically what happens is, whenever someone is charged with an offense, okay, he is, depending upon the nature of the crime, either arrested and produced to the magistrate, and then what magistrate does is either gives him the bail depending on the nature of his offense. If the offense is bailable, so he will give him bail, okay, and otherwise what he will do is he will either send him into judicial remand or police custody depending upon the nature of the crime. Judicial remand, police custody means if the police wants to conduct investigation, if the police wants to conduct further interrogation of the accused, then the police might ask for what? The police might ask for the judicial custody or police might ask for police custody. ठीक है? तो ऐसे लोग जो हैं जिनका अभी conviction नहीं हुआ है, but they are still under the police custody in some jail, so that is called, these people are called under trials. Okay, so their trial is going on, but they are not yet convicted of a crime. ठीक है? So this is very important figure. 76% prisoners in India are under trials. Ratio is highest in Delhi and J&K. Okay. Out of 4,88,511 prison inmates, 3,78,848 were found to be under trials. Now we will be looking at the socio-economic and socio-political distribution of such prisoners. Okay, among the under trials, about 20% were Muslims, while about 73% were Dalit, tribals or OBCs. ठीक है? तो 73% were Dalit, tribal or OBC, and about 20% were Muslims. Muslims form 14% of the population of country. Yet they accounted for 20% of the total under trials and 17% of all convicts. Convicts means the people whose guilt has been proven in the court of the law. Okay. Dalits, who form 16.6% of the India's population, accounted for around 21% of all under trials and 21% of the convicts. Equal number of under trials and equal number of convicts. Okay. Now tribals, who form 8.6% of India's population, accounted for about 10% of under trials and 14% of convicts. The number of convicts is greater than the number of under trials. OBCs, who form 41% of the total population, accounted for about 42% of the total under trials and 37% of all convicts. Okay, so this data is not very much important to remember, but what is important is the insight that this data gives us about the socio-political milieu of the country, or about the socio-political representation of the crime in country. Okay. So most of the communities, this means the communities which are not performing well on socioeconomic indicators are prone to more litigation. Litigation means they are prone to higher crime rates, and of course higher number of under trials are from those communities itself, right? So this is one of major important insight given from this data. Okay. According to the data, about 30% of under trials remain in jail over a year, while 65% do not get released before 3 months. Okay, about 30% of the under trials remain in jail. Why? The major reason is their cases don't come up into the courts for hearing. Okay, so about 30% of under trials, without any charge being proven, they are languishing in jails. They are innocent because they have not been proven guilty, and still they are languishing in jails, and there are 30% of under trials who are languishing in jails for more than a year without any conviction, and 65% do not get released before 3 months. Okay, about 50% of all under trials are charged with offense against human body. Offenses against human body are rape, murder, attempt of murder, kidnapping. Okay, so these around 50% of under trials were charged of these offenses, and around 20% of under trials were charged with offenses against property. Property means, offenses against property means theft, stealing, burglary, house breaking, all these crimes. Okay. The majority of under trials were basically facing like grievous charges, because offenses against human body are more grievous than offenses against property, because of course the prison sentence for burglary, theft and house breaking is not more than the prison sentence for rape, dowry death, kidnapping, assault, attempt of murder and all these things. Okay. State-wise data, if you look at the state-wise data, Delhi and J&K are having the highest percentage of under trials in jails. Okay. So Delhi is having 91% share. Okay. J&K 91% of the share. Bihar 85%. Okay. This 91% means the total, the percentage of under trials within that state as a the number of under trials within that state as a ratio of total prisoners in that state. So 91% of prisoners in Delhi are actually under trials. They are not convicted. Only 8% of the prisoners in the jail in Delhi are convicted people. Similarly, in J&K, Bihar it is around 85%, Punjab 85%, Odisha 83%, and all India average is 76%. Matlab all over India mein 76% of the people who are in jail, for them the offense, the charge they have been accused of, that has not been proven yet. They are under trials. Issues of prisons, of course, overcrowding, prolonged detention under trial prisoners. Under trial prisoners need to be released, okay, but due to the due to the prolonged time that takes in the coming up of their files in the court for hearing, okay, their detention extends for a longer period of time. Many times many people have been like they need to pay a very small amount of money to get released, but they do not have that. The poor man remains in jail over a year without trial for minor offenses such as theft. Because many offenses you might have read कि an offense carries 5,000 rupees fine or 1 year jail. ठीक है? So many poor people have been put in jail because they were not able to pay this 1,000 rupees fine. Okay. Unsatisfactory living conditions, of course, lack of treatment programs, the allegation of indifferent and even inhuman approaches in the prison. Okay. We all know that many inmates can't even afford a bail amount. Now, what is a bail? There was a question in UPSC prelims 2021, this year itself, this last year, about bail. So what is bail? Bail is something, bail is available to under trials, whereas parole is available to convicted people. ठीक है? तो अगर आप under trial है, ठीक है? तो in many cases, like in an offense which is bailable, ठीक है? In a bailable offense, like theft is a bailable offense, but murder or rape is not a bailable offense. Now, bailable offense is such an offense where the bail can be granted by magistrate, and the person who is accused, he can ask for bail as a matter of right. We'll be looking a bit about bail, because this was question in 2021 UPSC prelims. A similar question, okay, about bail and parole was in UPSC 2021 prelims. Okay, what is bail? Bail is basically when an under trial, okay, ठीक है, okay, when a person is brought to the magistrate, ठीक है, when someone commits an offense, okay, he is brought to a magistrate in a court by police, okay, then magistrate can either grant him bail or he can deny the bail depending upon the nature of the crime. Now, bail is something that magistrate can let him go, ठीक है, in return for surety, ठीक है, of bond. For example, if person commits offense, he is brought to the magistrate. Now magistrate sees that the offense is bailable offense, ठीक है, so he can grant him bail and say कि ₹50,000 जमा कर दो कोर्ट पे, and then you can go home. If that person is able to pay that bail, he can go home. So the main aim of this bail is कि although the police has brought him to the magistrate, the person has not gone to trial. Trial means where his guilt is established or innocence is established. ठीक है? So in that case, trial will happen, but to make sure this person comes to trial, ठीक है? This person comes to trial and does not evade the judicial process, the magistrate can ask him to fill a bail bond of ₹50,000, ठीक है, and can go home, but he must come to the trial court when his case goes to trial, ठीक है. So magistrate although assumes that he is innocent, okay, or if a minor offense, he can grant him bail, ठीक है. In cases of minor offense, the magistrate himself can grant him bail, and when he pays the bail amount, he can go home, and although he is not discharge of the offense, but he can now live at his home. Similarly, to make sure that the offender does not evade this judicial process when the case goes to trial, he can ask that person to fill a bail, है ना, and that too only in the offenses which are bailable, ठीक है, not in case of a murder case, not in case of देखो magistrate can grant bail in murder case also, in case of rape also, but that is his discretion, okay, it is not a matter of right. But in petty cases, petty offenses like theft and all these, the person can ask the magistrate to grant him bail in return of filling bail bond as a matter of right if the offense is bailable. Okay, so this is a difference between bailable offense and non-bailable offense. Now what is parole? ठीक है, तो parole, तो I hope you understood the bail. Now parole, once a person gets convicted, ठीक है, and he goes to Tihar jail, for example, Tihar jail, and he is serving a sentence of, for example, 10 years. Suddenly there is a marriage of his blood relative, ठीक है, so the person can ask the jail authorities, okay, that since my daughter is going to be married, I want to attend that, kindly grant me parole, ठीक है, तो parole is granted, ठीक है, but it is not a matter of right, it is not a matter of right, ठीक है, it can either be granted, ठीक है, it can either be granted or cannot be granted. But in case of bail, what happens is, if the offense is bailable, the accused can claim bail as a matter of right, ठीक है, fine. So we saw all this because there was a question in UPSC prelims this year, ठीक है. Now there have been recommendation of various committees regarding the conditions of under trials. Law Commission 268th report said that those detained with offenses less than 7 years, ठीक है, for a murder offense is more than 7 years, for a rape offense is more than 7 years, means for grievous offenses the punishment is more than 7 years. For lesser grievous offenses, ठीक है, the offense is less than 7 years. So this law commission said that in its 268th report that for a person convicted with an offense having punishment less than 7 years should be left, basically he should be freed after completing 1/3 of that period, ठीक है, like 5 years का है तो 3 years का है तो 1 year अगर उसने पूरे कर लिए जेल में तो he should be granted freedom if his conduct has been good, ठीक है. Similarly, if the jail term is for more than 7 years, तो half of that period, ठीक है. For example, if 10 years, तो 10 years का half 5 years. अगर किसी का conviction 10 years के offense में है and he is serving a jail term for 10 years, तो law commission says that he should be granted relief after 5 years. Okay. Justice Amitabh Roy Committee 2018, very important. Justice Mula Committee and Amitabh Roy Committee, you need to remember names only, nothing more. So Amitabh Roy Committee of course said that setting up a fast track course, है ना, to deal exclusively with cases like for which the pendency has been more than 5 years, because many people cannot afford good lawyers. Such cases do not even come up for hearing, ठीक है, and people languish in jails. So if for such cases fast track courts can be set, ठीक है. Use persons who are charged with petty offenses and granted bail but who are unable to arrange surety, ठीक है. अब surety क्या होती है? The one we talked about, right? कि अगर आपको bail चाहिए, bail means freedom, complete freedom, ठीक है. तो अगर आपको bail चाहिए तो, and if the person is not able to arrange surety bond for himself, like if the magistrate says कि 50,000 rupees आप submit करके and you can go home, ठीक है, या आपका fine जो है fine submit करके you can go home, but that poor person is not able to submit that fine. In that case, a very important personal recognizance PR bond can be filed. PR bond means कि a person will not be submitting 50,000 rupees ठीक है, not be submitting 50,000 rupees, but instead he will sign a paper where he writes that if I get convicted for this crime again, so I will be paying rupees 50,000. This is called personal recognizance. Okay, PR bond. Similarly, Mulla Committee in 1980, ठीक है, Justice Mulla Committee, the lodging of under trials in jail should be reduced to the bare minimum. So under trials should be kept separate from convicted prisoners, and speedy trials and liberal bail provisions. ठीक है, तो bail provision should be liberal and speedy trials. So similar as Amitabh Roy Committee for fast track courts for larger pendency cases. I hope you understood this. If you have any questions, kindly ask me in the comment section.